wherever you are, welcome. And thank you ever so much for being with us today. We have an exceptional program for you, Ask an Executor. If you were with us on Tuesday, then you already know how amazing Joe and Teresa Coleman are. If you haven't, I'm telling you, you're in for a treat for the next hour. I would like to also thank Mark Williams, who is our Senior Associate Director, and Natasha Roberts, our Assistant Director. Both of them have been invaluable on this and all the previous webinars that we've been doing. And if you have questions after this, please contact me or Mark, and our business cards are on your PowerPoint. And if you just click on one of them, it'll take you right to our email immediately. So with that, I want to thank you all for your support of the Carter Center. I also really want to thank you for the trust that you've given to us to give you this kind of information. There is really nothing more personal than talking about someone's estate. If you think about it, this is not a conversation that makes anyone comfortable. Mark happens to be a trust and estates attorney. And I encourage you, I am not an attorney, but I certainly encourage you to seek one out if you have not yet created a will. With that, I'm going to turn this over to Mark to have him answer. Well, just let you know that there is a disclaimer. Of course, this is being recorded. And then Mark will introduce Joe and Teresa.
Well, as a lawyer, always the favorite place for me to come in, the impenetrable wall of incomprehensible legalese. I won't read the entire disclaimer to you. What I will say is that it's there to let you know I am an attorney, but here today, I'm not going to be giving you any legal advice or creating any legal relationships. In fact, you're in luck. You really don't have to listen to me much at all today. So Joe and Teresa are going to be leading the program for us, thankfully. One thing I will say is that what we really do want you to know as a part of this educational program, that this is just such a very important topic. As you're thinking about your estate plan and the person who is going to basically run that plan for you, this is the person you're choosing as an executor. It's so important to pay attention. And we just have the good fortune of having worked together with Joe and Teresa. We really found a husband and wife team who have done this together. They've done it on multiple occasions. And so with that, I wanted to, before we sort of get going in terms of talking about your individual bios and things, if you might just give us just a quick sneak peek about the number of times you've served, or sort of the quick circumstances under which you were asked to be an executor.
Okay, sure, I'll start. I've been an executor 3 times. Twice were with family friends, friends of the family that I've known for 50 years or so. And then once it was with my family. And they were all 3 totally different in the way they were dealt with, but they were all simple. I mean, they were, no, not simple. They were all, there was a path to follow, and you followed them, and we moved on and finished it.
And I have only been put in that role for 1 estate. And I was actually the successor, not the original intended executor. And it was for my father's estate.
Well, thank you both for that background. And I asked you to share that because I want folks to know we have multiple different situations where you all have served as executors, and they've been under some sort of unique circumstances that people may not think about, but they could still face. So thank you for that very much. And I also want to just say, I'm so glad, again, getting to know you both over the last few years has been such a pleasure. And I'm so happy to be the one to be able to welcome you today and to thank you for becoming or coming on and sharing your expertise with us. Teresa, I'll start with the professional career in pharmaceutical development. I think everyone knows that means that we're talking with someone who is quite intelligent. What I also do want to do is just tell the folks, for those, you maybe know Teresa, some of you in the audience, and if you don't, as we were on earlier talking about the cute baby kittens that she is fostering right now, she's got another today. if your heart could melt by distance and virtually, I think this kitten would do the trick. Just bless you so much for taking care of all of these animals. I know it's a true love of yours. Joe, I also wanted to thank you too. After a career in corporate finance, Joe recently was doing some traveling, and I had the opportunity to follow along by Facebook. I'm glad you made it back safe and sound. And I'll finish by saying, I wanted to say this last quote here, a believer in the idea, the words "every day matters." I mean, truly a saying to live by, Joe. I appreciate you saying this and sharing that with our folks, because I think it certainly matters.
When I left corporate life, I wanted a new calling card, and I put my name on there and a phone number, and I said, that's not enough. I figured it out. And so I just came up with that phrase. But now there's an advertisement on TV that uses that slogan. So I'm wondering if I should have done a copyright.
Yeah, let's talk after. Copyright claim. Well, I'll thank the folks in the audience who helped with contributing questions in advance. And just remind everyone, if you've got questions as we go along, please do use the chat box to submit your questions. We'll try to answer those as we can as we go along. But if I may just ask you both, how and when did you find out that you were going to be an executor the very first time?
I'll start. In every case, it was probably 2 or 3 years before I needed to be the executor that on a face-to-face discussion with all of them, they asked me if I was willing to be the executor, and I said yes. And so it was as simple as that. That's how I got to know I'd be it come.
For me, it was a little, oh dear, I thought I unplugged that, sorry. It was a little less clear. My parents did not share their wills with us before they passed away, so I didn't know that I was second in line to be the executor, and really only super found out about it when my sibling, who was the executor, was failing to perform the duties and responsibilities, and the court basically said, "You're named, will you take it? Will you become the personal representative for this estate?" So that was after my father had passed away several months. So it was not something I had been planning on.
So it sounds like this is a real true difference in your experiences, one knowing about the appointments as executor, and then Teresa, you not knowing. So I wonder if you might talk to me then, Joe, about how the people preparing their wills, their wishes, the discussions you had with them had the opportunity to inform your decisions and your work. And Teresa, how maybe having had that opportunity would have helped you or changed things as you went about the process?
Well, for me, it was really nice that I got to talk to them beforehand, because I saw their trust and will, and was able to make sure I understood what their intent was, because later on we'll mention something that was confusing. But by having spoken with them, it was extremely beneficial in directing me to follow their wishes, and that's what you're trying to do.
Yeah, since I did not have that luxury or that opportunity, so my parents had drawn up wills that were fairly simple, but there was a lot of nuance that wasn't addressed. And so it actually was a little challenging, not so much in actually dispensing or dispersing the assets or whatever. It was the things that weren't included that became much more issues and contentious issues within the family. So the personal items.
Thank you very much. And so one thing I'll add, just from my personal experience, when I was practicing law, working with individual clients, I was actually surprised the number of times I had clients come in and say they didn't want their will to be made available to their family members until after they had passed away, almost as if it were some big secret. And so I'd ask you both if you could give a piece of advice or your opinion probably on this. Do you think it makes sense to take that approach, or do you think it makes more sense to try to, if you're considering this estate planning process, talk with your loved ones, and especially the people who are going to be your executors?
Yeah, it was really, it's been beneficial for the people to talk to their beneficiaries, especially when it comes to personal items. That's where it seems to be confusing. And so,
It's helpful.
well, I think I got off the question a little bit, but anyway, Mark, I'm sorry.
No, it's okay. The idea, just thinking if, do you think that, would you give people the advice that they should probably talk to their beneficiaries and especially their executors, the people who they're choosing to
Yeah.
serve in that role?
Yes, I do. And like for one of the cases, I know that the parents said to their kids, I want you to go through and we're going to do this together and tell me what you want and make sure that, one couple, the kids didn't have any idea the millions of dollars that they were getting, a couple $1 million. And I think it was better that they didn't know how much they were getting beforehand, because it would just make the family situation odd if they knew exactly how much dollars they were going to be receiving.
Excellent.
And from my side, I think it's a very good idea to have those conversations ahead of time, because if you've gone to the trouble of really thinking it through for yourself, and if you really do have some desires or wishes or particular personal items or allocations, and there might be some questions, et cetera, why not just get it out in the open ahead of time? And it certainly, in my particular situation, it would have made it a lot less contentious, I believe, if it had just been more clear.
Excellent. Thank you both so much for sharing that. I'll move on now to the next question that we got. And so I'd like you guys to both think back to those times when you very first found out. What was that initial gut reaction, that flash of emotion that happened when you found out you were going to be executors?
Wow. In my case, all three cases, I felt very honored. It made me sit up straight in my chair, because I knew, wow, they've chosen me. There's a reason that I've been the chosen one of everyone, be it an individual, or they could have gone to an institution to do their will, but I take care of their will. So that's the way I felt.
My reaction was panic. I think that would be the fair way to put it. Since I didn't really know about this, I knew that there was an issue with moving forward on probating the estate. But I didn't initially expect that it was going to fall into my lap. So I really wasn't mentally prepared at first, but you do what you have to do. And I was asked, and it was a reasonable request, and it was clearly outlined that that's the path that should be followed. And so I did it.
That's excellent. And it's a wonderful segue into this idea. You mentioned the word probate, and we've tossed it around, those of you in the audience, a couple of times. I'll just sort of give a quick, probably too fast explanation about this being the process where you go to the court with the will, and you basically ask them to let you bring it through to completion. So in that sort of very basic context, what I'd ask you guys both is, sort of, how would you describe that probate process from the perspective of the executor, and then what was your role in it?
I'm going to start by also throwing out the fact that there's such a thing as a will and a trust, and so sometimes we'll be using those words and they get intermingled, and for the purposes of this discussion, they both are virtually about the same. But the process was very simple, in my opinion, is that I knew I had to go to the court, to the county court office, and because every county is different, and I got from them the steps of what to do. It was easy to follow these steps. You go home and write them down, and you start going to these institutions, and you report to the bank, to the court on time what's happened, and then they tell you when you're finished. And it was pretty simple.
Excellent. Teresa?
So for me, it ultimately was pretty clear. Initially, as I said, I was a little caught off guard. And so because this was a contentious issue, and the court had to assign me as a successor personal representative for this estate, which was being probated in Colorado, although we live in California. I had to, find out, what do you do in Colorado? And actually they were very kind and gave me some links about which forms I needed to be filing initially. And then also I was directed to the website that spelled it out. And there's actually a little brochure that they have online that says, okay, so now you're the personal representative, this is what you need to do. And that was it. It was seemingly, it was pretty straightforward. It took a lot more time than I had anticipated it was going to. For me, every investment account and or stock was handled differently. So every single thing I had to work on or do, it required me to provide different documentation, provide different assertions, et cetera, go through different channels. I mean, just getting access to a couple of the accounts was challenging in the first place because I wasn't the original executor. But ultimately, what I needed to do was pretty straightforward. It just was a little more.
I'm going to summarize. One way I looked at this whole thing was, it was sort of like going to a college course where you had a lab and you study the material and then you execute it. And when you're all done, you get your grade. And the court won't let you not get an A. You're also the only point person. You're the only person that the court talks to. So you're in the middle of the court and all of the financial institutions or everything that you have to deal with. So that's neat, that being the point person.
That's a great point, and something that I was really hoping you might emphasize. And I wanted to circle back to something that you mentioned earlier, as you mentioned having to go down to the county courthouse. I was going to ask this question, but it's come in from Sharon in our audience, who says, well, which county do you use? She says her mother lived in one county, but died in a senior care center in another. And so she brings up the exact point I wanted to ask. How did you know which county to go to, Joe?
Well, I knew that I found out that it mattered where they died. You quickly learn that you have to go to the county that where the people died to execute the state. And there may be some state in the United States that is different than that, but that's what I found it to be.
That's great. That's exactly what I was hoping you might share. And I'll say that you mentioned it could be different in different states. Some places look at where the person was actually considered, it's a legal term, domiciled. And that is sort of a really loose question. I'll say, if you get into that point and you're trying to figure that out, get a lawyer.
Yeah, I mean, if you're on a fishing trip down in Mexico, you're not going to have to do your estate down. You're not going to process it down there if they died down there. So,
exactly right. So thank you very much for making sure we got that covered. I think that's a wonderful thing. And to you, Sharon, thank you for raising the question. So one thing I'd like to actually go forward to, and so someone has asked, Paul in the audience asked, during the last session, Joe, you mentioned that gifts given prior to death are not sort of a part of the tax factory like they used to be. Would you care to expand on that? Do you have any more thoughts on this?
Sure. In the reading of and preparing for the trust and executing them, it became apparent that the tax laws are set up to where if a person gives assets before they die, there's such a thing as a gift tax. But you have, once you give at least $14,000 or some number like that, $14,000 a year, you have to report it to the government, but you don't pay any taxes on gifts until you give over like $10 million for an individual or 20 million for a couple. But the same thing after you die, you don't pay any taxes, any estate taxes. Nobody pays estate tax until your estate is so large, 10 million for an individual or 20 million for a couple. So I hope that explains that.
I would say that's a great lead off, because that is, I believe, what Paul's question was getting to. There are some important things you can do with tax planning around what's called the annual exclusion. Joe, you mentioned that $14,000 per year before you have to worry about the gift tax. The way that it works beyond that step is that, say the gift tax is now $15,000 this year. Let's say you both decided you wanted to give $15,000 to a niece or something like that. You could do that for a cumulative total of $30,000 and not ever have to report the gift. But once you start going beyond that amount, you have to tell the IRS. The IRS does another funny thing where they say, okay, there's this 10 million for individuals, 20 million for couples that you're allowed to give as gifts. And they sort of count backwards from that number once you cross the $15,000 threshold. That's way down in the weeds. So I would say, Paul, please, if you're thinking you might run into a situation where you're looking at a gift or estate tax situation, please definitely talk to an attorney about that. That'd be really good advice. So that's calmed down on the boards for a minute. We'll move on to some of the other questions submitted before. I'd like to ask you guys if you could talk about, through the probate process, as you worked with the courts, the other parties involved, what kinds of documents and things did you need to do to effectively do the job?
Wow. First of all, of course, you need the trust or will, and you have to read that cover to cover and understand it as much as possible. And then well, I found that by going to the county clerk and getting there, they give you a checklist of what you need to do. And you go into the law office or their library next door and go to the books that give you that have the instructions of each one of those items that you have to do. They have the instructions and the forms that are required. And you simply follow the rules. These are set up, the courts set these up to be knowing that all types of people are going to have to execute trusts and wills, and therefore they make it as simple as possible for people. The documents are pretty much laid out for you.
So what I found is that I had to always, it seemed in every instance, I had to have a copy of the death certificate. I had to have a copy from the state of Colorado of the letters testamentary that I was the successor personal representative. Sometimes I had to provide a copy of that. Sometimes I didn't, depending upon what the particular asset was that was being discussed or disseminated. I might have to have notarized signatures. I might need to have a medallion that was
A gold medallion is sort of like a notary.
Yeah, for certain types of things. And I would find out really by talking to the various funds or the stock people or whatever as to what it was they needed. And so oftentimes I didn't really know what they needed until I was able to contact them, explain what I needed, give them the information that I needed to give them. And one other thing that they all seemed, or many of them seemed to need was upon death, you no longer have a social security number. You then have it's a TID, right?
Tax identification.
Tax identification number, which is different. I didn't have to actually get that because that had been done by my sibling when the probate was initiated. But
that was something she had to file for separately. Is that right, Teresa?
I believe that was my understanding.
Yeah.
I also never had the luxury of ever being able to converse with my sibling to find out what had been done, why it had been done, where any of that documentation existed. I was completely in the dark. So I may not be, my situation, I hope, is not typical.
Yeah, and I was able to get the social security numbers or the new tax ID by simply calling the social security office, and then they told me what to send in. I did, and then I got it within a week. Actually, they told me right over the phone what the temporary one would be, and I was able to use that ID going forward.
Excellent. So those are things that's very helpful. A lot of things people, that I would imagine many people don't think that, in the last year, when you're thinking about the final paychecks and tax returns that wind up needing to be filed, that something could be different. That's not just a person's social security number. So that's a really excellent piece of advice to add. Thank you both so very much for that wonderful insight. Joe, please.
Real quick. Also getting the last year tax return, the federal tax return, if they had any assets that have any income, they'd be listed there because there was income that they had to report. So from that, you'll know that's just another place of reference as to where their assets are if it isn't clear in their trust or will.
Excellent. So that's a wonderful another piece of advice. Did you help use that in any way, sort of putting together the pieces, knowing for maybe places you need to look, institutions, things like that, potentially creditors?
Yes, it turns out that all three of mine and Teresa's, there was no money owed to anyone. So luckily we didn't have to deal with that. We did have to file an announcement in the newspaper that the person had died. So the creditors have to have the ability to make a claim if they wanted to. But even though I didn't find any new investments to have to deal with, I was at least able to validate that I had everything covered that was in their tax return. So I know I had a feeling that nothing was missing.
Yeah, Mark, one other thing I wanted to mention was in the instance of my father, he passed away in March. And so we actually, thankfully, Joe understands a lot of this and was able to walk me through it. I had to file a tax return for when he was alive. And then I had to file a different documentation for the remainder of the year or
That's right.
And subsequent couple of years.
Yeah, it was tax return for the estate while it was
before
still
the estate had been distributed.
So all excellent advice for people who may not know what sort of timelines they're looking at and the different types of things they might need to be aware of before accepting an appointment as an executor. So you guys literally are hitting on all the things that I would hope we might share with people, even things we didn't get to on Tuesday. Thank you. Let's keep the momentum going here. I wonder if you just tell us a little bit, as we've talked loosely about the process and sort of things that go on, can you talk to us about your responsibilities, things you maybe were allowed to do or not to do, either according to the will or to the judge?
Yeah, boy, that's really the most important, one of the most important points is that you are responsible. You're the point person. It's important to think like the decedent, and that will help you get it done.
So from my side, responsibilities, there were certain forms that had to be filed. I had to do estate inventories. The other thing that I had the responsibility for was I had two of the beneficiaries in the will wanted copies of the accounting and they wanted copies of various documents. And by law, I have to provide that. I mean, I was perfectly happy to do so. That actually had been the breaking point of why I ended up being pushed into the successor personal representative role, was that request had been made repeatedly of my sibling, the real executor for the estate, and was not followed up on. And that led to a breaking point within the family, which then got the court involved. So it was my it is still my responsibility to make sure that if there is information that needs to be disseminated, that I do so. I have chosen to do any communications with all of the other beneficiary recipients. We're talking a small estate. We're not talking anything like what Joe was dealing with, but I have use the U.S. Postal Service certified mail to be able to prove that I did indeed send the documentation, and I kept copies of everything that I was doing. One thing I did was I kept a notepad, and every time I called someone or I talked to, or got a letter or any kind of communication, I tried to document it so that I could fall back on it if I needed to. Because I was expecting that there might be a lot of blowback, which there hasn't actually been that bad. And then in my situation, the only other thing, sorry, just real quick, was because it was so contentious and because of the way that I was brought into the process, the judge actually required a follow-up conversation 3 months after I was appointed. He wanted to have a conference call, which happened to happen right at the Carter Center weekend, I might add, and wanted an update from me, which I think is very unusual. But in this particular situation, because there had been such a fracture within the family, he wanted that done.
The second bullet, what were you allowed and not allowed to do? Well, you have some discretion. it's not written down, but turns out one of the estates, I'll say my family, the dollar amount was, well, my dad did a trust before they passed away, and they were going to give money to 20 different family members, and he all detailed as to everybody's going to get all this stuff. Well, by the time he died, they ended up with only like $15,000 of assets, period. And so I chose to not burden the courts by going through a probate process. I never even told the court about it. I just simply, because my family is close enough and I talked to my brothers, I just wrote a check for $3,000 each, and we each got our fair share of that. Well, our share of what I decided would be an adequate way of dealing with that particular estate. And the courts never heard about it, and they're happy with it. They don't, that's one less piece of paper they have to deal with.
So this is another excellent reminder from you both, Joe, here now, that, individuals, as you're out there, depending on the sizes of the state and the sort of dynamic between the family members, there are times and opportunities where something like that can work out. And for folks who hopefully will not find themselves in Teresa's position, it pays to sort of think down the road about who might come in as your executor as a backup. And you may really think about being explicit about the process for how that happens, conditions under which that might happen, and being very clear to the people who you're potentially, asking to do those things, letting them know one versus the other, that, I'm counting on you both if one doesn't perform. So these are all really great points. I thank you both. Please, Joe.
The first bullet, back to that. One of the estates, I went with the family and the son to the attorney 4 times before they died. And we were going through the trust to make sure that I understood what their intention was. Even though it was written down, it was extremely helpful to be able to just even go to the attorney with the person who has all the, whose estate it was. That was, I think, it would be really beneficial. It would be good to do.
Excellent. Thank you. That's another wonderful point. Some folks don't even think about maybe having that inclusive kind of conversation, but I'm hoping after this discussion today that many will more seriously consider that. Again, I was always surprised in practice the number of folks who wanted their estate plans to be a complete secret until they're gone, like they're, revealing a David Copperfield magic trick or something. But I wanted to quickly share with you another question that came in and see if I might, it's sort of between our discussion points and seems to be a good one, Teresa, especially given your experience. So, have either of you ever dealt with a Colorado beneficiary deed and or a California transfer on death deed? Were those a part of either of your estates?
No.
Not that I'm aware of. No, no.
Okay, so apologies there to our anonymous questioner. But what I will say, transfer on death deeds, from what I do know about them, they really vary on a state-by-state basis. It's much like a transfer on death bank account or a pay on death bank account. What that's meant to do is to be a tool to help you avoid probate. Basically, what happens is when you pass away, whoever the other person is on that deed, it's as if you never existed and they always existed and they just have whatever you had. So that's kind of a real dumbed down explanation of that in a way, but please, Joe.
Yeah, well, it turns out that I'm going to change my answer to yes.
Oh, please. Okay, yeah, great.
And that was one of the estates in California. It was a $2 million estate. All of the assets were in 8 different financial institutions, and I was the executor, and I was to disseminate the funds amongst 5 different family members. And so I was going to go and close all the accounts and blah blah blah. Turns out that the title of the bank accounts and other accounts had a beneficiary in each case. So there was a beneficiary, which is the same as pay upon death. That person was entitled to all that asset. So it turns out that there's one son who was a beneficiary of all 8 accounts. He got the whole $2 million. But luckily, he was wise enough and decided to follow what the trust said. The trust assuming that there was no beneficiary. Anyway, and so he disseminated the money, and everybody's happy and they go forward. But beneficiary titling.
That's a great point. So, and that's what those instruments are really all about. In terms of the beneficiary deed, I'd be really surprised. Same with the transfer on death deeds. If you're really interested in those, I guarantee you the state has a law that talks about them. It is very state law specific on how that works. So please spend a little time doing a little bit of legal research down at the courthouse like Joe did. And once you feel like you've got your feet wet at that point, maybe start reaching out and having some conversations with some estate planning folks, or either some real property attorneys if it's a home or something like that, if it's real estate that you want to transfer, and they could probably help you out with that. So both of you, thank you so much. And as we have more questions, please keep them coming in out there in the audience. I want to move on to the next question and ask you both if you could just share with us what your biggest surprise was as you served as executor. It could be from any point. If you have sort of surprises from multiple areas, by all means, we're happy to listen to those too. I think this might be a ripe hunting ground, so to speak.
I think I slipped by telling you what my biggest surprise was when I found out that the trust that was written by an attorney completely conflicted with real life, and that the assets were not titled in the trust. They were the owner of the people with the money and with the beneficiary to receive all the money. So there's this conflict of what the intention of the trust was different from what the law is about who legally owns the asset.
And based on the beneficiary designation too, right? I mean, so that was the document that was to control, since the trust didn't own the policy or the financial things, right?
That's correct.
So
that's right.
that's a great point to make, Joe. Essentially, whoever did that gave themselves two estate plans,
Yes.
and they conflicted.
Yes, yeah, that was a surprise. Probably nobody else will get that, but that was a surprise to me.
So for me, aside from the biggest surprise being that I actually was the successor personal representative, which was a big surprise, I think it was also I was surprised how much digging I had to do to find out what was actually in the estate and what wasn't. And it came down to, there were just a couple of bank accounts that it was very unclear if they were in or out, but it turned out that in both situations, the way they had been set up, they were not in the estate because they were set up as joint accounts between one of my parents and one of my siblings. And upon death, it went 100% of that asset went to the sibling and was not considered part of the estate, which was interesting.
Yeah.
Thank you. I have to imagine that came as quite a surprise and probably led to a few bumps in the road.
Well, yes.
And it's just like anything else. The first time you do it, it takes 100 hours. The second time it will take 20 hours. And so that was a surprise that it was simple to learn, and you just follow the steps and it gets done.
Excellent. Thank you both so much. Now, as we've gone forward, Teresa, I know this is going to apply in your situation. So perhaps I'll ask you first to talk about the disagreements you encountered and how those were resolved.
Well, a lot of the disagreements that actually happened before the actual dissemination of the estate came into play. And what really occurred in my situation, which completely fractured my family, I'll just be honest about it. It's a little challenging still for me. It turned out that there was a terrible conflict between two of my siblings over some personal items that were not specifically called out in the will as to who was to be the recipient. There had been an understanding that one thing was going to go to one sibling and something else was going to the other one, but that didn't end up happening. And so there was no way to really concretely resolve that. And it ended up, as I said, causing a huge fracture, which remains to today and has been incredibly difficult. So if I had any idea ahead of time, I would have asked that, even though it might seem ridiculous, to go through and have that conversation with your beneficiaries. And if there's something that really is important to them and really has meaning to them, and they really want to know that that's going to stay with them as they go forward, then put it in. You know, it doesn't have to be something that's worth a lot of money. If it's a lot of sentimental value for whatever reason, just delineate that it's not just the bank accounts that really had the impact. And in, you know, in my situation.
So I wonder if I might ask, I know you did mention something during our last session, and I want to ask you about that now. You said that some of the disagreements have even gone so far as to be still ongoing, in that the people you're trying to send money to from the estate won't actually take the money by cashing the checks. Is that still?
That is true, yes. Yes. So half of the estate, half of the proceeds from the estate are still in limbo. I wrote all the checks. I sent them all by certified mail. I sent detailed letters with each one, and documentation about why I was doing what I was doing, why they were getting what they were getting, what the distribution was, etc. And those checks have not been cashed. And now I'm at the point, because this wasn't that large of an estate, that banks have found a new way to make money. If you have below a certain balance, you pay a monthly fee. And so I'm getting charged $25 a month for an account that has this money in it, because I can't get someone to cash the check. And so now at this point, I think my only recourse is to go back to the court and say, okay, I don't know what to do. You know, help me.
I really appreciate you sharing that, because again, as we sort of talked about disagreements and unanticipated disagreements, my thought was that, you know, most people would think, you know, even if you're in a situation where you're disagreeing with family members, once the money starts going out, people would cash the checks. So just be aware out there, folks, that, you know, if there are things going on in your families, it makes all that much more difference now to go ahead and be very transparent about what you're doing. Try as best you can to explain in as much detail as you can to your loved ones, those who will inherit, those who will be your executors, what your motivations are, so that you don't run into these situations. It's a lot easier to spare your family this up front than it is to come back later on and, you know, have them going through difficulties like this. So thank you both so much for that. I did have someone ask about you filing a motion into the court registry to basically have the court hold the money and be a custodian of the account. And without sort of knowing specifically about Colorado, I will say that's a pretty common remedy that courts will say, if you really want to wash your hands of something, you can say, well, we're going to turn it over to you guys in a custodial account, and whenever the day comes, it's there for whoever. So Melody, thank you very much for adding that point in.
I'm making a note right.
Melody's been on for the last couple webinars. Thank you so much for that. When I mentioned the pet trusts last time too, so she's given me some homework too, but I've certainly learned a lot. Thank you guys.
We have a parrot that will outlive us, and our trust attorney said, well, that's not something we put in the trust, but there is some other separate document we have to identify where that goes, where the bird goes.
And that's an important point to make. So too, it really does depend on the state where you are, where pet trusts are or are not alive. Probably the most famous case of that ever happening was Leona Helmsley, a very well-known New York real estate magnate who passed and left tens of millions of dollars to her pets, and the New York state courts decided they didn't really like that so much. So
when Liberace died, he had 2 Borzois, and I wrote to the estate to see if I could take them over, but adopted it.
Oh, did you get a reply?
No, I never did.
Hey, that would have been a pretty interesting outcome. I didn't know that. All right. Let me go back. I skipped a step. So one of the things that we're kind of getting at here, I think, and what we're hoping to educate people on, is thinking about this idea of who it is they're going to choose as an executor. And so for those people who are doing this, they're thinking about their estate plans, or they're currently preparing them. What kind of advice would you give them when they're thinking about this person?
I firmly believe, after what I've learned, is that having a friend, family friend be the executor is better than having a family member be the executor. Because I've seen that when a family member becomes the executor, the rest of the family is separated somewhat. And it would just seem to be better that if it was a friend as opposed to the family member. And of course, then you can say, if you don't really have a person like Teresa and I, we don't really have a friend, except for you, Mark and Barry. We don't have friends who we would entrust to take care of our estate. And so we're willing to have a financial institution be our executor.
So that's one other thing that came up last time, hasn't come up yet, but I appreciate you mentioning this, letting people know that there's an option. You don't just have to choose a friend or a family member, someone you know personally. There are professionals who do this for a living, bank, trust companies, law firms, things like that. So I might wonder if you'd answer that question as you guys considered going with a professional executor. Specifically, were there things that you thought that would guide how you selected the professional?
We actually trusted our estate attorney, our estate planning attorney. We explained our reservations and concerns, and this was before everything had transpired on my side of the family. But just, it was apparent even back then that there was an opportunity for friction, etc. So we relied on her recommendation. But I will also say that going with an institution is expensive, and I actually I'm not really certain how much they will be charging, but I know that when I was speaking with the judge and my sibling and etc. initially a few years ago, one of the reasons that I said, yes, I will take on this responsibility is because it is expensive to have an outside third party take over and be the executor for the estate.
Yeah, as Barry had mentioned, it can be as much as 5 or 6% of the value of the estate. Whereas when I've done it as an individual, the reading that I did implied, it wasn't an exact number, but it was implied that about a 1% fee would be appropriate. And on a $2 million estate, that was going to be $20,000. And in my case, I chose not to. I couldn't take that much money because it didn't take me that much time. And so I just charged by the hour, $75 an hour, and I got $2,500 or something like that.
And as of this point, I haven't taken anything. In fact, I haven't even reimbursed myself for my own costs for anything, you know. For
Teresa, may I ask, how many hours would you estimate that you've spent on the work with the estate?
Well, are you talking my anxiety hours or my literal hours?
I would say let's just give everybody an idea of both, right?
We don't want to go through the anxiety hours.
Okay, okay.
The literal hours, boy, I really have no idea. I sat it, you know, virtually every account would take at least 4 or 5 hours of time on the phone and filing the forms and going down and having them notarized, and then, you know, making the right copies, and then contacting the court again, etc. So I don't know. I mean,
period of time, maybe we can look at that. The
Sure.
hours get spread out over time. One of these was taken care of, and well, my parents was 0, but one of them was about 3 months before it was done, and the other one took longer, more like 9 months to take care of everything. And so you're constantly aware. I mean, you're thinking about that all the time. You always have something to do. There's always something that you can do during that time period. It's just getting it done. So it's 100 hours is easily a number, probably more.
Thank you. And the real reason why I asked you guys to kind of think about that and guesstimate is because I suspect many people, as they're thinking about this person who will serve as executor, don't really think about it taking that amount of time, both the actual, you know, physical hours and then the time you spend thinking about it. And that's why this issue about executor compensation becomes so important. I will say, Joe, you mentioned sort of that it would have been a percentage for you that would have applied, probably under state law, I guess, or was it the document itself that would have supplied the percentage?
It was only instructions and sort of word of mouth. There was no checklist in the law that told me how much to charge.
Okay. And so that's a great thing to think about as you're thinking about asking people to serve in this role, folks. You really want to make sure that you're considerate of their time, because they're going to be doing a lot of things for you and your loved ones if they're not one of your loved ones. So as you look at it too, one of the other things to be aware of, I'll just sort of flag Georgia as one of those places for any of you from Georgia. There's a statute, a state law on the books that says, you know, if your estate is worth this much, then here's the percentage that you will pay an executor or a trustee. And if it goes up to the next level, here's the additional percentage you're going to owe on this next amount. And it keeps going up, sort of like a tax bracket. So the more that you ultimately have, the more that you technically could owe. And if you're not very explicit about that, then it's something that may actually come back to bite your estate. So just think about that, folks, as you're out there working on these estate plans. And Joe, please, thank you. Yeah.
I remember reasonable compensation is what I kept on coming across.
And that'll probably be something I'll say to you, everybody else out there, that is often one of the things you hear. And that means a lot of different things depending on who you engage, especially if it's a professional. So be careful out there. It's one of the traps for the wary and the unwary. So now, one of the other things that we've sort of been trying to do throughout this is to help people understand, you know, that are going to be executors, you know, what kinds of things should they be prepared for. But if you had a piece of sort of parting advice you might give to someone who's going to step in the role, what would that advice be?
First thing is to breathe, just breathe, because it can get done, and it's you can deal with it. And then maintain a to-do list of what you need to do. Otherwise, things will slip between the cracks and you'll have to do them anyway later on. And document every conversation that you have with anybody on this. Those are my points of advice.
Excellent. Thank you, Joe.
Yeah, I would agree with that. I would also agree with what we talked about earlier. If you in any way have the opportunity to be able to have discussions with the individual for whom you will be serving as executor ahead of time, take advantage of that so that you really do have an understanding of what it is that they wanted and why, so that you are comfortable that you really do understand what to do.
Yeah, and know that you were chosen for a reason. There's some reason why you've been the chosen one. So just take that to heart.
Mm-hmm.
Excellent advice. I think hopefully, you know, you follow those words and you should do no wrong. That's the thing always, to uphold those expectations. So we've kind of alluded to this throughout the conversation, and it's sort of a lead into our next month's webinar where we'll focus explicitly on trusts. But it sounds like you guys have had some experience sort of with a trust or as a will, one versus the other. Or both. And so I would wonder, do you guys have any thoughts about a will or a trust as you've seen them work in the executor positions or the probate situations you've been? And could you talk to people about how they might think about these sort of generally, if we're sort of finishing off with this, and we're providing links to 2 in-depth webinars on that information. But I'd love to capture your thoughts on that.
Boy, I first of all I would lean toward make sure you have a living trust versus going to having a will. A will in California has to be probated and go through the courts. But in a living trust, if your assets are entitled into the trust, then the executor simply has to file with the court that you're doing this trust, and then you execute according to what the trust said to do. You don't need approval or verification from the court. You just do everything in it, and I think it's a simpler matter. And wills in California tend to be only for smaller dollar amounts. That's my understanding, is a small dollar amount is will's okay over a trust.
However, that having been said, having gone through the process of probating a will that was generated in California and was expected to be probated in California, but ultimately ended up being probated in Colorado, it would have been so much cleaner had it been a trust. It would have been much simpler. I believe it would have been more straightforward. And I think that was a terrible misconception that at least, and bad advice that at least my parents were given, that their estate wasn't large enough to need a trust, because it really honestly would have been simpler in many ways, I believe, although I am not an attorney, so, and I am not an expert in that. And then there's one other thing that I would stress, and I'm not sure, Mark, if this is coming up on the next slide or not, so I might be jumping the
There's no
gun.
more slides.
It's all right. We're at the end. Yeah, please.
Yay, okay, then I'm going to put this out there. For me personally, what this experience has really highlighted is it's okay. In fact, in many ways, it would be really wonderful to do your giving before you die, so that those who are going to be the recipients actually know about it ahead of time, and you can go ahead and disseminate that, and it's just be out there and be clear. And then one other thing I did want to mention, and I promised Joe I wouldn't step all over his toes this time, make sure that you double check what the name of the organizations are that you want to be the recipient of your estate proceeds. Make sure you've got the right organization, because we personally had that experience. You want to talk?
Yeah, sure. We wanted the Carter Foundation when we first started. We didn't realize when we started with the Carter Center, we didn't realize that that wasn't the Carter Foundation. So we told the trustee or the trust attorney to put the money, our biggest chunk into the Carter Foundation. They got back to us and said, "Are you sure you want the Carter Foundation? Because that's a film organization." And they said, "You probably want the Carter Center," and we got that clarified right away too. So that was really important point.
Yeah, and we had explained why we were doing that and who the Carter Center were, and where they were, et cetera, et cetera. So that was our astute attorney, or they wrote it down.
And Barry wants to say something.
We're a little
on that.
foggy on that. Yeah, Barry.
The Carter Center regularly, we receive communications, even funds that are intended for the Carter Foundation at our address. So it does happen. And one point that Joe brought up a few minutes ago, in terms of the cost, at a $2 million estate, he was entitled to 1%, would have been $20,000. The bank or the law firm would have charged 6%, $120,000 that would have gone for the same purpose and considerably less money to those who you really wanted. So selecting an executor really is a very, very important decision to make. We did not have a chance to talk about working with more than one executor, but that is also a very strong possibility, where you have someone who's an expert, say, in the arts, and somebody else who's an expert in real estate and so forth. And that too is something that should be considered. I want to take a moment and just thank Joe and Teresa. You've given, not just on Tuesday, but also today, and all the preparation. It has been a truly wonderful, inspiring, and very fast hour both times. I also want to thank Mark Williams. You have been a great moderator and host today and Tuesday. And I think kudos to all of you. My name is Barry Nicholsberg. I happen to be the Chief Development Officer for Estate and Gift Planning at the Carter Center. Mark is Senior Associate Director at the Carter Center. And Natasha Roberts is our Assistant Director. If you ever have a question for Joe, Teresa, or one of us, please do not hesitate to use whatever means you'd like, phone or email or text or however, to get in touch with us. For everyone at the Carter Center, I want to thank all of you who participated. I again want to thank Joe and Teresa Coleman. And I look forward to seeing you next month when we have Ask a Trustee. That I believe is the 10th and 13th or something close to it of May. We'll be in touch. God bless.